Here in Nevada, the insanity defense is listed under NRS section 174.035. And we have what's commonly known as the M'Naughton rule, which stems from 1843 in Great Britain when Daniel M'Naughton intended to kill the prime minister, but accidentally killed his secretary instead. And ultimately what the M'Naughton rule says is that in order to prove that you're not guilty by reason of insanity, you have to show that you were in such a delusional state that you lack the ability to appreciate and understand the difference between right and wrong. Here in Nevada, a defendant can enter a plea of not guilty by reason of insanity prior to trial, or even assert an insanity defense during the course of a trial. And what happens is the burden would then shift to the defendant to show by a preponderance of the evidence that they were acting under a delusion that justified or excused their behavior. We've seen some really morbid examples here in Las Vegas where you hear news about a mother who's bludgeoned her child to death, and then you come to learn that that mother was suffering from postpartum depression or some other mental health problem, and honestly believed that that child was possessed by the devil, and that killing that child was necessary to protect the community from greater harm. It sounds crazy, but there are people that truly suffer from mental health breakdowns where they commit atrocious crimes because they honestly believe that their actions are necessary to prevent even greater harm. If at trial we're able to convince a jury here in Nevada that our client was legally insane at the time of the commission of the crime, that is a complete defense. However, our client would likely be facing being placed into a mental health facility until such time as there is clear and convincing evidence that they are no longer suffering from the mental impairment and no longer pose a danger and threat to the community.